Greetings and welcome to Judicial Sales, Court as the Vendor from American Jurisprudence. Let's get started. This is going to be an interesting one. So make sure that you get your popcorn or milk duds and you're ready for the show. Hit the like. Let's get going. So this is from the 2011 American Jurisprudence 2nd edition on judicial sales. Let's start with a summary. The scope. This article deals with judicial sales with particular discussion of property subject to such sale. Sales prior to final judgment or decree judgments. So sales prior to final judgment. We'll be going over that. Decrees or orders of sale. The conduct and effect of a judicial sale, including conditions precedent to such sale, the persons conducting such sale, bids and bidding, purchasers at such sale, payment, title acquired by the purchaser, distribution of sale proceeds, the report or return of sale, confirmation, validation, or ratification of sale, and relief from such a sale. Interesting. So this is going to cover a wide scope of areas involving judicial sales. So federal aspects of federal legislation authorizes judicial sales to enforce money judgments in federal courts. Interesting. So there's a lot of things that are treated elsewhere. Homestead property, validity of sales, see AmJur and homesteads. There's quite a few other ones in here that peace officer's authority by valid writ of execution directed to him or her to sell property levied upon. Interesting there for sheriffs, police, and constables. All right, let's get started here with the article. Section 1, generally, the definition. A judicial sale is defined as one made under the process of a court having competent authority to order it by a person legally appointed and commissioned to sell, and which is subject to confirmation by the court. Interesting there too. And it becomes absolute only when confirmed. At a sheriff sale, also known as a judicial sale, the court is the vendor. The officer conducting the sale is an instrument of the court, and the stability and integrity of the court is of paramount concern. That's from footnote 3, Commercial Federal Estates Savings and Loan Associations versus ABA Corp., and that is 1988, Nebraska. The term sale, as used in the expression judicial sale, is a word of precise legal meaning and refers to a contract to give and pass rights to property for a consideration in money, which the buyer pays or promises to pay for the thing which is the subject of the sale. That comes from Binns versus Isabel, Ohio Appellate. That was 1943. So, a very precise legal term, sale, as used in this expression of judicial sale. So we're into the terminology. It's worth reading again to really solidify the understanding when they say a sale. It refers to a contract. What kind of contract? This is a contract that gives and passes the rights to property. And as with any contract, value and consideration, that property is of value, and in the consideration is money. And that money is either what the buyer pays or promises to pay. So notes, bills of exchange, things like that, perhaps, for the thing which is the subject of the sale. The distinctive characteristic of a judicial sale is that it must be the result of a judicial proceeding. A judicial proceeding. Interesting here, not administrative. But we'd have to read this case here from Illinois Appellate Court, Northeastern District, 1952, First District here. But Guttel versus Hillebrecht. This must be an interesting case here because the distinctive characteristic of a judicial sale is it must be the result of a judicial proceeding. Thus, a judicial sale must be based upon an order, decree, or judgment directing that the property be sold, as distinguished from a mere judicial assent to the sale of the property under statutory provisions authorizing certain sales by fiduciaries. So there's a distinguishment from a mere judicial assent to the property under statutory provisions. So we are talking about a decree or judgment directing as opposed to a mere judicial assent to the sale under statutory provisions authorizing certain sales by fiduciaries. It must be made by the court or by its direction upon the terms and in the manner provided by the decree or order, which in turn must conform to all pertinent statutory provisions regulating judicial sales. So the order must be conforming with the statutes, but the statutes alone would not be sufficient, it seems here from my reading. Again, nothing in this program here is to be misconstrued, used, or misused for anything personal, private, legal, lawful, financial, business, tax, or otherwise. This is strictly for the informational, educational purposes of this YouTube channel, so don't do this at home. Let's continue. Another characteristic of a judicial sale is the court's decree of sale acts upon specifically described property. Moreover, the sale must be for money, either in cash or in deferred payments, unless the interested parties agree otherwise. Footnote 10. Who agrees otherwise? Gibbs versus Ewing. Florida, 1927. Will they get it for coffee beans? Wonder what the other is. All right, let's continue. And the sale must be reported to and confirmed by the court which ordered it. In short, a judicial sale is a judicial act. And in making such a sale, the court acts as the vendor in the transaction. That's footnote 13, McCartney versus Frost, 1978, Maryland. Whew. So that's a little bit of a big chunk there just in the definition. Now let's get into the distinctions here in section 2. Distinctions between judicial sales and execution sales, the effect. A sale made under a general execution is not strictly a judicial sale, because a judicial sale is one made on an order to sell a specific property by an agent of the court, acting on the court's directions, and is a sale made by the court as vendor on confirmation. Remember, it must be confirmed. Sometimes there appears to be no clear distinction between the two types of sales, where a court uses the term judicial sale in an overly broad sense to include execution sales, particularly where the court is concerned with the application of a general principle common both to judicial sales and sales under final process. So let's see here. We're not getting all those. So I'm looking for the distinction here of what makes an execution sale, a clear definition here, and I still don't see that yet here. Although certain common principles apply to both judicial sales and execution sales, there may be statutory provisions which apply only if the sale is a judicial sale. Moreover, a person ordinarily entitled to purchase at an execution sale may not be eligible as a purchaser at a judicial sale. And the consequences of a judicial sale, as to the title acquired by the purchaser, may differ markedly from those flowing from an execution sale. And that's as to property and interest passing under judicial sale, see section 102. We're not getting to that tonight, but I'm still wondering about this execution sale. No, we haven't gotten to that yet, and we're not going to let this slide. We need to know more about an execution sale. And you know what that means? That means we need to go over to Black's Law. Wow, what's up with the chat here? Not refreshing. Oh, good Lord. Give me a moment here. Let me try and get this chat going here so we can respond to anyone that's in here. Okay. Huh. Let me try a little something here. There we go. Excellent. All right, let's continue. So we want to find execution sale. I'm not sure if we're going to find it under execution or under sales, but we could probably start with E for execution because that's going to be the first on our stop. This being a scanned document takes sometimes a while to catch up, but we will get there. Defendant's gain, the amount of property, the value of property that criminal defendants obtained by committing a crime. Wow, defendant's gain from 1882. A lot of serendipitous definitions we come across on the way to, well, now we're looking at EX, so let's really move it down here. It's going to be at the end of, here we go. Oh, geez. Pass it. Come on. All right. So it's I would implore everyone to get a copy of Black's Law, especially a hardcover, so you don't have to deal with going through the scanned one. Although there are better versions that allow you to search, which could be the benefit of the digital. All right, come on. We should be there soon. I have to jump it a little faster. There we go. Execute. Executive right. No. Let's check something here. Execution. Execution clause. Execution sale. I knew it. C sale. Okay, that's why it's up there. We're going to find it though. Seems like we have a pretty low turnout tonight. I'm not sure if notifications went through. People come late, that'll be okay because we'll have this word defined by the time they arrive. All right, yeses are way down this list. Let's give it a second to catch up. It kind of like stalls in certain places. Oops. Oh, Lord. Jumping all over the place here. There we go. Sales, execution sale. Similar sales, short sales, memorandum, lots of sales, foreclosure sale. We can look up judicial sale while we're at it. Why not? Judicial sale, a sale conducted under the authority of a judgment or court order, such as an execution sale. Also termed sheriff's sale. Case is execution. Judicial sales. Now we're getting a little bit of confusion here. Such as an execution sale, and we're saying there's a distinction. So let's look up execution sale, see if we can figure out this distinction. Oh boy. Execution sale, a forced sale of a debtor's property by a government official carrying out a writ of execution, also termed forced sale, judgment sale, sheriff's sale. See execution. And then we have an executory sale, a sale agreed upon in principle but with a few minor details remaining. So the execution sale is a forced sale of a debtor's property by a government official. So it's a specific type of perhaps judicial sale, carrying out a writ of execution. So, all right, so let's continue with the reading, and perhaps we'll get a little bit more clarity to these distinctions, because it seems like there is a big distinction between the two. Yeah, indeed, this is a big difference here. A lot of sales that might be execution sales are labeled judicial sales, but they never had a true decree, which means they weren't confirmed. And if they're under the color of being judicial sales, perhaps they weren't legitimate. Let's continue. So let's read this again now with this insight. Although certain common principles apply to both judicial sales and execution sales, there may be statutory provisions which apply only if the sale is a judicial sale, and that's footnote 3, Lambert Lumber versus Petrie, Kansas, 1963. These are quite old cases. This seems to be well-established law here. All right, so moreover, a person ordinarily entitled to purchase at an execution sale may not be eligible as a purchaser at a judicial sale. And the consequences of a judicial sale as to the title acquired by the purchaser may differ markedly from those flowing from an execution sale. Footnote 5, as to property and interest, as we saw earlier, section 102. We could jump to section 102 very briefly just to see what that's all about. 6, 5, because we're not going to be making it to 102 tonight, I could guarantee that. Here's section 101, section 102. Property or interest passing under sale, assets passing with property. A judicial sale does not pass title to or otherwise affect property not mentioned in the decree, even though it is embraced and in the pleadings so that the court could order its sale in that proceeding. That comes from 1915 in Massachusetts. Silverman versus Betty. So it does not pass title to or otherwise affect property not mentioned in the decree, even though it is embraced in the pleadings, so that the court could order its sale in that proceeding. The purchaser of real estate at a judicial sale acquires title to standing timber, subject to any limiting conditions regarding its use and removal. So these are the extra assets on the property. However, a purchaser at a judicial sale acquires no title to or right to the possession of deeds constituting the chain of title of the person whose property is sold. That's from 1902, Gay versus Warren in Georgia. Acquires no title or right to the possession of deeds constituting the chain of title of the person whose property is sold. That's another interesting case to look up here too. Wow, so glad we took this little diversion here to section 102. Let's get back to where we were. All right, so those are our distinctions. We're getting there. Let's see here, section 3, judicial sales in federal district court. This could be interesting here. Since federal district courts may direct the enforcement of money judgments by procedures other than a writ of execution, judicial sales to enforce such judgments are also authorized. Judicial sales are governed by federal statutes, which limit the powers of federal courts with respect to sales made under order or decree of the court to the method specified. The provisions of these statutes are applicable only to sales which are required or authorized by court order. DeMarco versus Kurtz, and that's 1945. Wow. That's in D.C. Circuit. Judicial sales are governed, or I'm sorry, that's a D.C. appellate. Judicial sales are governed by federal statutes which limit the powers of federal courts with respect to sales made under order or decree of the court to the method specified. Footnote 2, that's from U.S. Code. All right. The provisions of these statutes are applicable only to sales which are required or authorized by court order. So that's in federal district court. And now we're on to Section 4, judicial sales of property on which the United States has lien. An action to foreclose a mortgage or other lien, naming the United States as a party under the statute, must seek the judicial sale of the property. If the United States holds a first lien on the property, the United States may ask for the foreclosure of its own lien and may bid its claim at the foreclosure sale. Oh, gosh. It's from U.S. Code. Now we're on to Section 5, property subject to sale. Unless a property is exempt from sale, the court has the power to sell under judicial sale any property, real or personal, tangible or intangible, which may be sold and transferred by the owners at a voluntary sale. The courts exercise a sound discretion in determining what property will be sold in a given case. Since a franchise which is granted to an individual and his or her heirs, personal representatives, and assigns is freely transferable, it may be sold pursuant to a judicial decree for the payment of the grantee's debts, provided the rights of the public in the franchise are not impaired by the use continues for the public good as originally intended by the grant. So, granted, franchise which is granted to an individual or his or her heirs, personal representatives, and assigns is freely transferable. So the franchise is freely transferable, so it may be sold pursuant to judicial decree. All right, now we're on to Section 7, generally, sale of attached property. As a rule, there must be a final decree before a court may order a judicial sale of property. Final decree. Moreover, where the action and controversy involve property rights, it is deemed an error for the court, on application of the plaintiff and before trial on the merits, to order the seizure and sale of such property by provisional orders, where such seizure and sale would render ineffectual a judgment later obtained after trial. That's Columbus Packing versus State in Ohio, 1922. These are some really old cases, long-standing. However, where the condition of the property is such as to require that it be sold for the protection of the parties, and the circumstances justify immediate action, or it appears that a sale is inevitable, and that an immediate sale is the best interest and to the advantage of all the parties, an exception to the general rule may be made, and a sale ordered in advance of a final judgment. Wow. The courts, in dealing with statutes authorizing judicial sales or sales without court order of attached property, have construed the term perishable or words of similar import to refer only to goods which, because of their nature or inherent qualities, are subject to speedy decay or loss, and the courts have excluded from the operation of the statute such things as lumber, timbers, metal tanks, implements, furniture used in connection with drilling for oil. Furniture used in connection with drilling for oil? A cotton press, and automobiles, and airplanes. All right. But not trains. Section 7, procedure, application for order and conduct of sale. Before we go on this, let's check over here to the chat. We have Facetious Expert. Greetings and good night. Good night to you all, and welcome to you all. Since it is a matter of necessity that the sale of perishables be made as quickly as possible, the procedure for obtaining an order to sell such property is usually informal, and applications may be made in some states by motion on affidavits or oral testimony, either on notice to the adverse party or ex parte if it is impracticable to perfect notice or the case is an urgent one. Where a statute requires that a notice of intention to apply for such an order of sale be given to the opposite party a specified number of days in advance of the application, except where it appears impracticable to give such notice, or the case is urgent, in which event the court may exercise of its discretion, grant the order without notice. Oh, geez. A failure to give the prescribed notice or to show that the case comes within a statutory exception deprives a court of jurisdiction to grant an order of sale. So there it is, a failure to give the prescribed notice or to show the case comes within a statutory exception deprives the court of jurisdiction to grant an order of sale. This is very interesting here. Failure to give notice or to show cause, there's an exception to give the notice. Where the application for an order of sale is opposed, it is deemed an error to grant the order unless a record shows that proof has been heard on the trial or argument of the motion. When the application for an order of sale is opposed, a party who has made an application for the prejudgment sale may withdraw such application without dissolving the attachment. Again, very old cases here, 28 and 1928 and 1905. Right, we're on to the effect of short sale and disposition of proceeds, Section 8. The proceeds of the sale of property sold at prejudgment sale take the place of the property itself. Disposition of proceeds. So the proceeds of the sale of the property sold at prejudgment sale take the place of the property itself. And such proceeds are subject to the same rights and liabilities as the property would have been if it had not been sold, so converted to money. Where the applicable statute makes no provision for the replevy of attached property, and the sheriff would be required to hold such property until judgment has been rendered on the attachment, the proceeds of the sale cannot be replevied by the plaintiff in the action. So I've heard what a replevin is in order to return property, and this is replevy and replevied. Let's see what the replevy of. You know what that means? That means we're going to the R's. Oh man, we're getting lucky here. Remedy. Replevin. So replevy. Miss it. There it is, replevy. Replevin. So it's archaic. But here we got replevy. It's a verb of 16th century. To recover possession of goods by a writ of replevin. To recover goods by replevin. So to recover by replevin is to replevy. So that means that we're back to replevin. For the 17th century, is an action for the repossession of personal property wrongfully taken or detained by the defendant, whereby the plaintiff gives security for and holds the property until the court decides who owns it, also termed claim and delivery. 2. A writ obtained from a court authorizing the retaking of personal property wrongfully taken or detained. The action of replevin lies where the specific, here let's zoom this in a little bit more, it's hard to read there, where the specific personal property has been wrongfully taken and is wrongfully detained, to recover possession of the property, together with damages for its detention. To support the action, it is necessary, A, that the property shall be personal, B, that the plaintiff at the time of the suit shall be entitled to the immediate possession, and C, that, at common law, the defendant shall have wrongfully taken the property. Replevin in the sepit. But by statute in most states, the action will now also lie where the property is wrongfully detained, though it was lawfully obtained in the first instance, replevin in the detenet. D. That the property shall be wrongfully detained by the defendant at the time of the suit. In rare cases, the plaintiff might seek equitable relief to secure return of a chattel. That's your movable property. More commonly, the claim for recovery of the chattel was pursued at common law under forms of action such as the detinue or replevin. Detinue. American statutes or court rules track the common law generally, referring to the recovery variously as replevin, detinue, I think that's how you say it, claim and delivery, or sequestration. The statutes usually allow the plaintiff to recover the disputed chattel before trial, though it is now subject to constitutional limits which have led to procedural revisions in many of the statutes. It comes from 1993, The Law of Remedies, from Dan B. Dobbs. So we have replevin in the sepit and the detenet. So the incipit, so replevin in the incipit, an action for the repossession of property that is both wrongfully taken and wrongfully detained. That's replevin in the sepit. And replevin in detenet, that's an action for the repossession of property that is rightfully taken but wrongfully detained. So incipit's really bad. Detenet is taken lawfully but wrongfully detained. All right, so that was a good deep dive into replevin. Let's get back to main. We got some people in the chat here. Let's see. Look up replevin. Oh, okay. Well, I'm on top of that. The chat was a little slow. Original owner, most likely, yes. Blazing Ash Hippie says, would third shift. Woo, third shift, yeah. All right, let's continue. So, again, the effect of short sale and the disposition of proceeds. So we had a short sale before the judgment. The proceeds of the sale of the property sold at a pre-judgment sale take the place of the property itself. And such proceeds are subject to the same rights and liabilities as the property would have been if it had not been sold. Where the applicable statute makes no provision for the replevy of attached property, the sheriff would be required to hold such property until a judgment had been rendered on the attachment. The proceeds of the sale cannot be replevied by the plaintiff in the action. Interesting there. There is authority to the effect of the true owner of the property sold at a prejudgment sale may recover such property from the purchaser, since the sale of the property belonging to a person who is not a party to the action does not confer good title on the purchaser. Let's proceed here. We're on section 9 now. Generally, decree or order as essential prerequisite of sale. There must be a final decree before the court may order a judicial sale of property. In other words, before there can be a valid judicial sale, there must be an order or decree of the court by which such sale is authorized. That's footnote 2 here. From Illinois Appellate Court, Northeastern District, 1952. Or First District here. Interesting here. But either way, it's Gittell versus Hillebrecht. So this looks like a pretty good case here, dating back to 1952. All right, back to the decrees. There must be a final decree before a court order may order a judicial sale of property. In other words, before there can be a valid judicial sale, there must be an order or decree of the court by which such sale is authorized. Although a court may have inherent power to order the disposition of personal property involved where the circumstances of the case require, in some jurisdictions, a court may have no power to order a sale of real property except as authorized by statute. Footnote 4, that's New York. And holding that outside the powers specifically conferred by statute, the courts have no general authority to direct the sale of real property. So that's in New York. Yeah, all right. All right, and in some jurisdictions, that's the one there, while in other jurisdictions, the courts may have power to sell real property in any appropriate case. And that's footnote 5, section 25. Great, so we'll be there soon enough. Federal legislation sets forth the manner in which the federal district courts provide for a judicial sale of realty or personal property. So there's federal legislation which will dictate what provided for the federal district courts. An order or decree directing a judicial sale is controlling upon the parties, and it fixes their rights and obligations. A sale made by an officer acting without the authority of a decree or order is deemed to be a nullity, even though it is subsequently ratified by the court. And if the power to make a sale has not been expressly conferred, the purchasers of the property are not protected. If the power to make a sale has not been expressly conferred, the purchasers are not protected. Footnote 9. That's from Rolfe Coal Mining Company versus Redden in West Virginia, 1926. Old coal mining days. Wow. Ordinarily, the judgment or decree directing the sale is, without more, the authority on which the designated officer acts in making the sale. Under a statute providing for the issuance of something in the nature of process for the enforcement of a judgment directing the sale of realty, in the form of a writ, where the writ recites the judgment has been entered, ordering certain property to be sold, and is accompanied by a copy of the judgment, it meets the statutory requirements and is immaterial whether it is entitled a writ of enforcement, writ of execution, or order of sale. And that's footnote 11. Knapp versus Rose in California, 1948. All right. Let's see, where is that? Okay, under the statute providing for the issuance of, so that was the one we just got there. Observation. There it is. Upon being petitioned to confirm a judicial sale, a federal district court has discretion to decide whether or not bid was egregiously inadequate, and in doing so should consider whether rights of third parties would be adversely affected by confirmation. Interesting there too. That's footnote 12. First National Bank of Jefferson Parish versus MV Lighting Power. A trial court has considerable discretion in setting a minimum price for property sold at a judicial sale and in deciding whether to confirm a sale over an objection that the price is inadequate. That's Citibank. Wow, 1981, so it's a much versus Data Lease Financial Corporation. Indeed. Let's continue. We're on to section 10 now. Stay of proceedings under decree or order. Jump over here to the chat and see if we're up to date on this. Indeed, we are. Please, if you just come in, hit the like. Let people know that we're here and live. So we're on to section 10, the stay of proceedings under decree or order. The court may, by order, in a proper case, stay proceedings under a decree or order for the sale of property as a matter of discretion upon such terms as it considers proper. Of course, injunctions against sales. See section 34. Interesting. We're on to section 11, the modification of decree. The court may modify the terms of a decree so as to justly and equitably enforce its judgment and render to the parties that to which they are entitled. Such an order serves both as a final decree adjudging the rights of the parties as well as providing for the manner in which the decree is to be enforced and for the assertion of rights declared in the decree. Footnote 2, that's Union Trust of Indianapolis. Of course, in Indianapolis, 1914. Where the original order of sale is a consent decree. It was a consent decree where everyone just agrees to the terms, doesn't have to be litigated on the merits. The court has no power to change its terms without the consent of all the parties, except on the ground of fraud or mistake. But under other circumstances, the court has the power to change the terms of a judicial sale as long as the sale is not confirmed, and the property and sale remain under the power of the court. A court which has ordered a judicial sale also has the discretionary power to modify its orders relating to the sale by subsequent orders, particularly after a sale not in full compliance with the court's original order has been made, provided no fraud, mistake, or surprise is shown and the creditors are satisfied. Even after the time to appeal from the original decree ordering a sale has expired, an application may be made to modify or change terms of the decree of sale for the purpose of removing an obstruction to the sale, or an action may be brought to effect such a modification. All right, we're on to section 12. Generally, a decree or order must conform to the applicable statutory requirements. Remember, the statutes are going to guide it in many states. It seems like this is 1909. We're really going back. Plains Land and Improvement Company in Montana. Although a failure to do so is not necessarily fatal, the order should state the terms and conditions of the sale. So statutory requirements might not be fatal, but it should state terms and conditions of sale. The decree should terminate all controversies as to the property between the parties to the proceedings, and in the order that the purchaser may obtain a title that is free from their claims. That's footnote 3. Another great old case, Gladys Bell Oil Company versus James in Oklahoma, 1924. All right, we're on to 13, section 13, irregularities and surplusage. A decree directing a judicial sale may not be invalidated by a direction that the party sold be delivered to the purchaser, or even though the direction would be void, by a direction that the officer charged with conducting the sale execute a deed immediately thereafter. A sale will not be set aside for a mere irregularity in the order, such as where the order fails to name the parties to the principal proceeding, or where it omits a recital with respect to the furnishing of a bond by the officer it designates to sell. So, little technicalities here, irregularities and surplusage. When we get to identification of property and sufficiency, since the purchaser of a judicial sale can only be put in possession of the land described in the order or decree of sale and the deed, the sufficiency or adequacy of the description is vital, and the purchaser at a judicial sale acquires no title to the property not included in the order or decree. Thus, the order or decree must describe the property with sufficient certainty to identify the property. Going back to 1915, El Paso. The federal statute relating to judicial sales setting forth the notice requirements provides that the notice contains such description of the property by reference or otherwise as court approves. The statute does not require that the property's description be correct to the minute detail. And that's U.S. versus O'Connell, 1974. So, it doesn't have to be correct to the minute detail. An order or decree of sale is deemed erroneous when it purports to confer on the officer designed to conduct the sale the authority to exercise his or her discretion in selecting the property to be sold, and an order of sale may be deemed insufficient if it directs the officer designated to make the sale to select for sale at his or her discretion a portion of a designated quantity of property. A judgment directing the sale of 3 graves in each of 3 numbered cemetery lots and containing a legal description of the realty in which such lots were located have been deemed sufficiently definite, and a decree for the sale of coal underlying an infant's land which sufficiently located and designated the tract as a whole had been deemed not void for uncertainty because it was not void for uncertainty because it was not specific in defining the location of 2 reservations of small parcels of coal. Wow. Old coal mining days. All right. Now we're on to section 15. It's generally where a decree of sale is rendered by a court of competent jurisdiction, it operates as an adjudication, presumptively at least, of every matter essential to the property and validity of such decree. Propriety. Let's read this again. Where a decree of sale is rendered by a court of competent jurisdiction, it operates as an adjudication, presumptively at least, of every matter essential to the propriety and validity of such decree, and is conclusive upon the parties to the action or the proceeding, and it precludes a re-examination of the matters adjudicated to the prejudice of the rights of a bona fide purchaser at the sale. And that comes from Wright versus McAuliffe, and that's in Ohio, 1937. The decree or order of sale is a public document, and all bidders are charged with notice of its terms and legal effect. Moreover, a bona fide purchaser at a judicial sale under decrees assenting to the sale entered by the owner's attorney of record will be protected, even though the attorney had no authority to assent to such decrees. A purchaser at a judicial sale of property of minors is entitled to assume that all necessary conditions have been fulfilled. So presumptions. These are your presumptions. And if they don't apply, then they need to be rebutted. Which takes us to section 16, matters concluded generally. When the court has jurisdiction of the action or proceeding and of the parties. So we have subject matter jurisdiction, personal jurisdiction. Its order or decree may not, in that court or in any other court, be impeached collaterally for irregularity or error in the determination of facts or of law, and such an adjudication is conclusive until reversed on appeal, or until duly set aside in a direct proceeding in the nature of appeal or otherwise, to impeach, set aside, or nullify the decree. And where there is no remedy of that kind, it concludes forever. And that comes from Tedder versus Irwin, West Virginia, 1911. All right. Now we're getting more technicalities. Section 17. The effect on particular errors and irregularities. A decree of sale may not be collaterally attacked on the ground of defects in the proof. Also, although there is authority to the contrary, a decree of sale is not usually open to collateral attack because of errors of law or fact apparent in the face of the proceeding. Thus, a decree of sale may not be deemed void because of an omission to file papers, attach process, or docket the case, or because a jury trial was denied in the principal action. Where there has been a sale, there can be no collateral inquiry as to the owner's death or administration, the existence of the amount of debts, the insufficiency of the personal estate, the existence of children, or whether a private act of the legislature as to the manner of the sale within its constitutional power. An error not ascertaining the liens before the sale must be raised by appeal and not by separate suit, attacking the decree collaterally. The same is true of alleged errors in decreeing the sale without having advertised it or in transferring a vendor's lien from one tract to another. Where the court is authorized to direct a sale by a particular officer, the sale is not void if the sale is ordered to be made in gross, although it should have been made in parcels. Again, some long-standing cases here. 1901, Ball versus Safe Deposit and Trust Company of Baltimore City. And that was footnote 1. A decree of sale may not be collaterally attacked on the grounds of defects in the proof. Then we have the effect on persons under disability, section 18. A decree directing a judicial sale is ordinarily not void because the defendant or some of the defendants who were under disability were not properly represented. And the sale may not be open to subsequent collateral attack on the ground that a guardian ad litem was not appointed for such a party. In such jurisdictions, persons under legal disability, when a decree or order of sale is made, are allowed a specified time after removal of such disability in which to object to the sale. That's an interesting one there. Those are some old cases too, except this Franklin one here from 1957. All right, we're on to section 19 here, and generally, the nature and extent of the title purchased at a judicial sale under a decree ordering such a sale is determined by the decree, regardless of the grounds on which the decree is subsequently reversed on appeal. The reversal of the decree of sale does not render the plaintiff in the action subject to an action for conversion. The rules pertaining to the effect of a reversal apply not only where a judgment directing a sale is reversed upon appeal, but also where it is reversed upon a motion in the trial court made in the same proceeding in which the decree was rendered, or an independent action brought for that purpose. Footnote 4. That's Harrow versus Johnston in 1940, Oklahoma. All right. So as you see here, as we've gone through this, there's a lot of references to very old case holdings and very little extra embellishments here, practice tips, precautions, and other things that are typical of American jurisprudence. So this tells us that a lot of what we're reading here about judicial sales is well established since the early 1900s and really hasn't changed much up to 2011. Now, what has changed in this? I doubt much, but it would be worth researching further if it did apply to you. With that said, we're going to leave off here so we could start next time on section 20, the reversal for error or irregularity. We're getting into a lot of these technicalities, and I know we're going to get into some more of the meat later on, so we'll save that for the next one. We'll do a part 2 of judicial sales. This has been quite an interesting dive into the court as a vendor to see the inner workings of these sales and the way the property is conveyed through these fiduciaries, agents, and officers. And quite an interesting topic. A lot of this stuff has been long-standing and not much changed, but it seems like a lot of it had been well established in the early 1900s, and a lot of this is under common law. So to see the statutory overlap of this and where it's going to some of the cases we've seen where it falls under statutory requirements for the execution of some of these acts, that it kind of it makes it a very complex topic. And that's why we're attacking it here with the American jurisprudence perspective. I salute all of you for being here, and I hope to see you all on the next one. Peace out.